There we are. Welcome everyone. Hi, and thanks for joining us today. This is the first event in the Easter terms Talking Animals Law and Philosophy series, and it's great to see so many of you here. We have yet another couple of people joining here. I'm just going to omit them as well. Okay, so my name is Raphael Fazell. As many of you may know, I'm the Executive Director of the Cambridge Centre for Animal Rights Law. Some of you may be attending the Talking Animal series for the first time, so I'm just going to say a few words about how these sessions work before I will introduce our speaker. So we will listen to a presentation that will last for around 30 to 40 minutes, and then have another maybe 45 minutes for discussion and Q&A after that. The event will end at approximately 6:30 p.m. UK time. As always, you are all very warmly invited to participate in the discussion, be it by making a comment or asking a question. If you would like to participate, then please could I ask you to use the chat function, which you'll find on the bottom of your Zoom app, or the raise hand function, which should be under the reactions button of the Zoom app. And I'll then go through the different raised hands, or indeed the questions or comments in the chat, and sort of either allow you to ask your questions directly or just sort of feed them to our speaker for him to respond. And until then, I will be muting all the microphones. For those of you who may only be able to stay for some time, we will be recording the talk itself, not the discussion, and we'll then be uploading it to our website. Okay, with this out of the way, let me now introduce our speaker. We have the great pleasure of having with us Professor Torben Spaak today. Professor Spaak is professor in jurisprudence at Stockholm University in Sweden. Previously, he was a professor at Uppsala University, where he also obtained his PhD. And he was also twice a visiting professor at the University of Minnesota Law School. Professor Spaak's research deals with jurisprudential issues such as the nature of law, the analysis of fundamental legal concepts, as well as legal argumentation and interpretation. Professor Spaak is the author of numerous articles and books, including The Concept of Legal Competence, published with Dartmouth Publishers, Guidance and Constraint, published with Justus, and A Critical Appraisal of Carl Olive Krona's Legal Philosophy, which was published with Springer in 2014. And most recently, he co-edited the Cambridge Companion to Legal Positivism that came out in 2021. His presentation today is entitled Animal Law, Human Duties or Animal Rights. And that presentation is based on a chapter that he contributed to an edited collection that recently appeared in the series Scandinavian Studies in Law. Torben, thanks so much for being here today. I'm going to hand over to you.
Thank you, Raphael. Thanks for inviting me. This is the first time I address an animal rights group or people interested in animal law. As you said, I did contribute an essay on this topic to this volume called Scandinavian Studies in Law, which was aimed at, well, animal law issues. So I wrote about legal rights or the concept of legal right, and now I'm here to try to tell you a little bit about this. So the title of my presentation is Animal Law, Human Duties or Animal Rights. And let me see so I can, the central question that I want to consider here, that I pose and that I try to answer is simply this: should we conceive of animal law, at least partly, in terms of animal rights? And my answer is no. And I'm putting it in perhaps in somewhat stark terms here, but I'm saying it would be pointless or else incoherent, depending on simply what we take a legal right to be. And this, of course, is what I will explain this in what follows. But so, as you can gather from this is very much a conceptual presentation. And usually, of course, substantive presentations are more engaging. And But I would try to make my main claims, to be as little technical as I can. If anyone's interested, just take a look at the piece I wrote if you want to have more details about various arguments. But I'll try to bring across here simply the main ideas. So this is perhaps my main claim. I label it A, and I proceed to make some other claims en route to the main claim, namely B, legal rights. I think of them as complexes of what I call Hohfeld elements. And I say, C, there are four main types of rights: claim rights, liberty rights, power rights, and immunity rights. And then I suggest, and this is important in this context, that the so-called will theory is preferable to the interest theory. And then finally, I say, what's interesting for animals, as far as I can see, are claim rights, not liberty rights or power rights, etc. I would say very little about animals, except that my assumption here, my starting point is that animals, of course, are valuable and they exist for their own sake, not for the sake of humans. They are not instruments for our satisfaction. They have lives of their own, and we should respect that. That doesn't mean that I believe that animals have moral rights, but it does mean that I believe we have moral duties toward animals. And I will elaborate a little bit on this difference, because at first you might react and you think, he's saying they don't have rights, but I mean rights, something fairly specific when I say they don't have rights. I'm not saying we shouldn't respect them. I'm not saying they don't have value, far from it, but I am saying they don't have rights. And this is really the topic of my presentation. So let me say a few introductory words about conceptual questions, because at least not for philosophers, but for lawyers, legal scholars, generally people with legal training have little patience with conceptual questions and want to go to the questions of substantive law and get an answer to the question, who has what right? But conceptual questions deserve some considerations. They're not the most important thing. They don't have to be at the center of everything, but they shouldn't be ignored. So conceptual questions are not factual questions. They are not normative questions, but they are their own kind, so to speak. So what's a concept? Well, experts disagree about this and can actually spend a lot of time speaking on this topic. I'm going to assume what I think is intuitively acceptable and certainly not very problematic in my view, namely that concept is essentially, not exactly, but essentially the meaning of a word or a term. I say the sense here to distinguish it from the reference. But the meaning. So if you take, let's say, the concept of this, take the term, the word discrimination, or or discriminate against, it has a meaning. What does it mean, you might say? You want a definition, let's say, and the definition essentially is what I mean by the definition will capture the concept. And on this analysis, you have the term, that's the word. You have the concept, that's the idea, the notion, what you understand by the term. And then finally, you have the object or the property that falls under the concept. Not every word functions like this. We have so-called natural kind words, but many words, certainly words that interest us in legal studies, tend to function like this, that you have the word has a meaning, the meaning determines what falls under it. And I also want to say this about conceptual questions. They are not moral questions. Depending on how you understand, I'm not going to speak about this, but because I feel there will be too much talk about this, and this might actually be a bit boring. But conceptual, you can analyze, as philosophers know, you can analyze concepts fairly strictly along the traditional model when you bring in a priori intuitions to determine which analysis is correct and so on. And you have an analytical equivalence between what you analyze and how you analyze, and then you say this is necessarily so. But you can also explicate concept or rational reconstruct them. That is a looser and more well, a more relaxed approach to conceptual analysis. And it does involve evaluations because you will have a purpose with your explanation. The purpose might be fairly general, such as being adequate for legal thinking or such. Or you can be more specific, wanting it to fulfill a certain role in, let's say, in animal law. But I try to speak generally about these. I'm more on the explication side here because I think the way I see it, many concepts, the one that we meet, certainly in the legal sphere, I'm not sure it's fruitful to think that there is a right answer to the question of what a right is, or what jurisdiction is, or what validity is, or so on. So I think of these questions more along the lines of explication, where you mold and shape and refine a given concept, and you do this for a purpose, so that your explication will perhaps not be true or false, but it will rather be adequate or not adequate in relation to the purpose. But the point of saying this here now is that conceptual questions might bring in values, but they are not moral questions. That is, I think, is important, at least for me in this presentation. So I'm going to come back to this. Now, if we think a little bit about the concept of a right in general, then I would say that the function is to protect the right holder by imposing normative constraints on others. And this is indeed why we think of rights as having peremptory force, as they say, in the sense that they trump competing considerations. So to be a right holder is to be normatively protected, not least against general, utility-based arguments or arguments from the common good and such. The idea is that the individual, the right holder, is protected. He or she has something that stops the aggressor from, so to speak, attacking you or legislating, for example. So this is in rough terms. There is nothing very original about this, but this is what I take the function. Here's one thing, and now I realize I'm digressing a little bit, but it's interesting when you think of the legal sphere. You may ask yourself, okay, we speak of rights. What exactly do we do with the concept of a right or a concept of legal rights in legal reasoning, specifically in legal problem solving? And it seems to me, and here I'm not dead certain, but I'm inclined to think that we speak of legal rights most often in legal conclusion. If you imagine a legal argument, you have premises and you have a conclusion. Then my suggestion here is that we tend to speak of legal rights mostly in legal conclusions. That is, we describe the law of or the lay of the land, the law of the land, once we're done arguing. But if this is so, then it seems the concept of a legal right doesn't play an important role in legal problem solving, because it is what you arrive at, not what you start out from. This can certainly be debated, but this is my general impression. If, on the other hand, you were to, and sometimes, of course, you do start out from the assumption that someone has a legal right. So you put it in the premise. And then there is an interesting question, well, how do you arrive at a more specific normative conclusion that a person, let's say you begin by assuming that a person has a right to practice his religion. And then, but that usually you want a more specific normative conclusion. Does this person have a certain liberty or a claim or something? And then the question is, how do you go from the assumption that this person has a legal right to the conclusion that he or she has this specific liberty or claim or power or whatever? Here you could distinguish between, should we look upon this as, should we think there is what you might call a logic of rights, where you can, using the methods and techniques of legal reasoning, spell out the normative conclusions fairly, if not mechanically, at least in a fairly clear and determinate way? Or should we think of it as policy reasoning rather, so that you begin with the right and then it's really a matter of policy reasoning on the part of the courts to determine what exactly you may or may not do? This, I think, is an interesting question, but I admit it's not of central importance today. But since I was saying something about first the function of the concept of a right in general, then I wanted to say something about how it might work, this concept might work in legal reasoning, and for that matter, in animal law. Now, what I think of rights is that I think of them as what I call complexes or conglomerates, if you will, of Hohfeld elements. I will explain to you in a second what a Hohfeld element is. But the idea here is that rights are molecules which consist of atoms. And now we will take a look at the atoms. And here is Wesley Hohfeld's fundamental concepts, which he presented, I think, almost 100 years ago. But they are, they have been much appreciated by at least legal philosophers and jurisprudents who like this schema. The general point here is to try to refine well, legal thinking in the sense that Hohfeld argued that, or he reasoned that if we think of legal problems or legal analysis in terms of rights and duties, well, then that is too crude. We need to be more specific, have a more refined conceptual apparatus, and that is what this is meant to be. So I will explain roughly what this means, the schema, and then I will go on to say that a right is a complex of these atomic elements simply. And then you can develop this claim a bit further. And I will try to do that by bringing in the will theory and the interest theory of rights. And once I've done that, I will turn to consider animals. Okay, so this, well, the idea is that if you look to the left, you have four concepts. You have duty, claim, liberty, and no claim. To the right, you have power, immunity, liability, and disability. And the idea here is that if you understand, and I think we do understand what a duty is, something you must do, and what a power is, something that you can do, legally speaking. You can change legal relations by performing a certain kind of act, a declaration of intention, an act in the law. In Germans call it a Rechtsgeschäft or a Willenserklärung. So if what the schema means now, you take the vertical lines, which indicate that these, there are always two persons involved here. So they indicate that duty and claim, liberty and no claim, power and liability and immunity and disability are correlates. So this means that if I have a duty to pay you $100, you have a claim that I pay you $100. If I have a power to change certain legal relations, well, you have a liability because it's your legal relations that I can change. The diagonal lines, on the other hand, indicate that these concepts are contradictory. For each person, he or she has either a claim or a no claim, either a duty to do something or a liberty not to do it, either a power or a disability, either an immunity or a liability. There's of course more to say about this, but the idea is that if you allow yourself to assume that you know what a duty is and that you know what a power is, then you can define the others fairly easily. So then you have these 8 concepts, which I myself, I like them very much. I agree with Hohfeld that you can be a little more exact in your analysis of legal relations, certainly in animal law as in any field. And well, and this I would say is generally a good thing. Now, if we proceed, I would say that given what I just said, it's natural to distinguish between at least 4 main types of rights. And I call them claim rights, liberty rights, power rights, immunity rights. And as you can see, I'm simply drawing on the concepts Hohfeld introduced here. And I will say that, and I will come back to this, but I think that for animals, claim rights are the most important things. I'm not sure that the other rights make any sense even with animals, but claim rights, such as a claim to be treated well, or not to be, a claim not to be subjected to various, to experiments or whatnot, that would seem to me to be very relevant for animals. Now, having said this, having said that we have these fundamental concepts and that you can distinguish between these different types of right, really depending on which of these atomic concepts is at the center of this complex of atomic elements. So here, the will theory of rights, the general idea is that if you're a right holder, the law recognizes your will or your choice as being determinative of legal relations. You are, as Hart put it, a small-scale sovereign. Here is a quote by Herbert Hart, which I think is very much to the point here. The idea is that of one individual being given by the law exclusive control, more or less extensive, over another person's duty. So he's speaking of claim rights here. So that the area of conduct covered by that duty, the individual who has the right is a, as he puts it, small-scale sovereign to whom the duty is owed. So the idea here with the will theory is that to be a right holder is to be in charge, is to be the person who can choose, for example, so if I have a claim right, someone owes me $100, I can, I control that duty in the sense that I can demand performance, or I can waive the duty and say, okay, I see that this is a difficult situation, you don't have to pay. Or I can take him to court. And if the court, if I do, and if the court decides in my favor, I could finally waive that duty, the court-based duty, so to speak. So the idea the whole time is that being a right holder is someone who can do something, who's in charge, who is, as Hart puts it, a small-scale sovereign. Now, oops, what happened now? Here I want to point out an objection that some consider to be very serious and others perhaps are not equally convinced by. But it's fairly, you see fairly easily that if this is what it is to be a right holder, then of course there would be problems conferring rights on children, on mentally handicapped people, and on animals, for the simple reason that it's difficult to see how they can be such a small-scale sovereign who determines, who is in charge and determines what other people, may or may not do. So that is, so this means, of course, that this theory was designed a long time ago to fit the field of private law and, of course, grown or adults of sane mind, so to speak. That's what we're talking about here. Children weren't, or animals, of course, no one thought of them in the 19th century. An interesting, so this is this is an objection then to the will theory. And the answer normally, which is roughly the answer I'm giving to you today, is on the part of the will theorist, is to say, okay, yeah, but it's not as bad as it sounds, because of course we can have duties to protect our children, to protect animals and so on. So there really isn't a problem here. But the implication here is that this is a moral objection. One may wonder how exactly one is to understand it. Is it a moral or an intellectual objection, this? But many, I think of it rather as more of a moral objection. So now I just said that the answer on the part of the will theorist is that, well, we have duties, no big deal, we have duties. Then some, and in this, I've taken this from William Edmondson's fine book on rights. I can't remember actually the title of it, but it's historically oriented and very illuminating. But he gives you this argument. He says that, no, this defense on the part of will theorists doesn't work. Why? Because rights provide much more protection than do duties. How so? Well, he says, rights function as side constraints on the pursuit of goals, which I think is true enough. What he means is that if I have a right, then let's say the government in particular, but not only the government, is constrained in the sense that this right will trump the various utility considerations, and generally all the arguments that go into the mix that would support, let's say, a given piece of legislation. So what Edmondson is saying here is that the defense that I just gave you, we have duties, don't worry, is that this is not a good defense, because duties just don't give us the same protection as rights do. Now I thought of this, and I think that there is something, indeed, I think it's a self-defeating claim, because you have to ask yourself, if it is the case that rights function in a way that is really different from the way duties function, then of course rights have to be something very different. And the only way that I can see for them to be very different from duties is that they are rights under the will theory, so that being a right holder is a small-scale sovereign, in the way I explained. Then you can say that rights are something different, more impressive, more protected than duties. But this argument is designed to show that the will theory is inadequate. So what's left? Well, what's left is the interest theory. And under the interest theory, as I will point out, rights really are nothing different than duties. Rights are just duties seen from the point of view of the right holder. So it's the same legal relation, because being a right holder simply means that you are that your interests are legally protected, for example, by the imposition of duties. But if this is so, then the idea of the claim that rights function differently simply doesn't work. So it seems to me that to even get this objection off the ground, you will have to assume precisely what the objection is designed to undermine, namely the will theory analysis. So I think there is something very wrong with this objection. But we might come back to this. You may want to ask questions about my reasoning here. But this was the last two slides here concerned a possible objection then to the will theory, namely that it simply can't account for rights that children and animals have, or that mentally. So the assumption is they have rights, and this theory can't account for this. But that, of course, assumes that they have rights, which we haven't. It really is the question at issue here. Okay, the interest theory now. So what it is that to be a right holder here is to have your interests protected by the other persons, the counterparty, I call him or her, his or her duty or disability or liability or whatever. And you may wonder, of course, well, so the difference between this and the will theory is that here you are a passive beneficiary. You are not active. You're not supposed to be in charge. It's not decisive here whether you can control the other person's duty or disability and so on. It's enough that you are protected, legally protected. And that's why I said a few minutes ago that on this analysis, a right is really, and I will come back to this, is really nothing more than a duty. Just it's the same legal relations seen looked at from two different perspectives. Here is Neil McCormick. He defended the interest theory, and this is not a quote, but this is how he put it in an article a long time ago on children's rights. So here he says that a person A has a legal right to X, let's say a certain treatment, to hospital treatment or something. If and only if conferring a right on A to X, to this treatment, the law is thought of as advancing the interests of A, and of course the class of persons he is a member, and the assumption is that X is, in normal circumstances, good for A. That's the interest. And the second part is that the law has the effect of making it legally wrongful to withhold X from A, which is the legal protection part. So here is McCormick on claim rights. And again, the difference between Hart and McCormick here is both are speaking of claim rights, but Hart introduces this notion of the right holder being in control in a certain way that I try to explain. Whereas here, McCormick is content to say that the right holder is a person who is protected, who is a beneficiary. And of course, as you can guess, or you can see, the interest theory is more generous in the sense that it allows a much greater circle of creatures to have rights. As long as you can reasonably say or plausibly say that this person or this animal or this group of creatures have an interest and the law protects it, then they are right holders. So on this analysis, of course, it is absolutely no problem to attribute rights to babies, rights to little animals, which is of course very attractive if you are, and many of us are, but some are even more concerned with, let's say, children's law or animal law, simply the protection of children and animals, and of course, perhaps people with disability or what have you. Now, the typical objection, which is also my objection to the interest theory, is simply that I call it here, I speak of redundancy. So what I'm saying is that on this analysis is in a sense attractive in that you won't be barred from attributing rights to anyone really. As long as there is some legal protection, you can say that this person or this animal has an interest. And I think we can fairly often say this. But the flip side of the coin here is that it seems to me you're not really saying anything, because once you've said that there is a duty, that let's say parents have a duty to care for their children, or humans have a duty not to inflict pain on animals, or something like that, then you have said, I mean, then that's the substance of the whole thing. If you also want to be able to say that, and therefore the kid, the child or the animal has a right, well, you can say that, but you haven't added any new information as far as I can see. And that's why I prefer the will theory, because what it does is to single out something that I think is important, that many have thought is important, namely this special role that the right holder is given by the law. And again, it is particularly well suited in the field of private law, of course. But anyway, so this here is having presented the interest theory, I present now an objection. This is the redundancy objection. Okay, now finally, animals. Here I want to say that animals, that claim rights, of course, seem to be meaningful for animals. I have doubts about the other types of rights, because since animals clearly can't have duties, it doesn't seem to be any point in saying they have liberties. I mean, in a vacuum sense, of course, they have liberties. If a liberty simply means the absence of a duty. So you can say that if you want, but nothing much has been said here. I'm inclined to think of it as a little confusing. Powers makes as much sense as duties. The animals can't comprehend and exercise powers. And they certainly would not be attractive to imagine an animal could consent to animal, experiments or something like that. Immunities are a little more difficult. Here we could imagine that there is in the, let's say, it might even be in the Bill of Rights and the Constitution, some provision that makes it impossible for the legislature to enact laws that would, let's say, put it crudely, be bad for animals. Then the question that my question now, that would of course be meaningful, but I doubt whether it would be meaningful to say that therefore animals have corresponding immunities, because an immunity is a protection against negative change of your own legal relations. But it seems to me that animals are not usually thought of as having any legal relations at all. In most legal orders, they have traditionally been treated as objects rather than subjects. Of course, I should add here something that confuses this argument a little bit, is that what we're discussing is the possibility of looking at animals as right holders. And if they're right holders, then of course they have legal relations. So I'm content to say that in any case, whatever the details of this argument about immunities, I think claim rights are the rights that are meaningful for animals. simply a claim that a claim to be treated well. Can be many more specific claims, of course, but that's something at least. Now, under the interest theory, of course, there is no problem. Animals can have rights. There is no problems at all, because we can easily, I think it's not a problem to think of animals as having an interest. Depends, of course, on what you mean by interest, but I would take a broad interpretation here and say they obviously have an interest not to be killed or put in little cages or being experimented on and so forth. But again, of course, there is what I call the problem of redundancy. So from my point of view, the way I see it is that there is little point in ascribing rights to animals if they already have, if we have duties. So I mentioned here the possibility, I'm not saying it will be completely pointless, because there may be a certain symbolic value, nothing specifically to do with legal thinking or legal reasoning, but of course it can be have a symbolic value to speak of animals as right holders, in the sense that you are simply expressing respect for animals, that they are valuable, that they have interest and so forth. So I'm not saying it is totally, but legally speaking, I don't think there is much point. Anyway, that is my my position. Under the will theory, well, that's the theory, as I've said 10 times now, that I prefer, because I think it's more, it gives you a more, it identifies a legally interesting position. But since animals can't reasonably be in control of the other party's duty or no claim or liability or disability, it doesn't seem to work. The obvious solution to the problem, of course, is to say that, well, they can have a legal representative. That's the traditional way of dealing with children. You say under the will theory, well, they can't have rights themselves, but they can have a legal representative. Here things get a little complicated, once you apply this to animals. But let's look at this is how I have to admit that I'm not up to date. I'm not up to date here with the latest on disability law or animal law. So what I present might have to be adjusted a little bit here if I've missed some new development. But I would say that it used to be, at least, that for someone to be a legal representative for a child, this person would have to be legally authorized, of course, and then to have a legal duty, a general legal duty to act in the best interest of the child. This, I think, is unproblematic. Then you're a legal representative. But here an interesting question arises, at least it's a theoretically interesting question, namely, who then is the right holder, the child or perhaps the representative? Of course, the point is to say that the child is a right holder, but will that work with this theory? And then the argument has been that, well, I name it 3 here. The child will one day become an adult and will then be able to have and exercise rights. And 4, that what the representative can do now that the child is a child is what the child could have done if he or she had been an adult. I'm not sure that I find this terribly persuasive. I'm not sure what to think. I can't say that when I see this, I think it's obvious. Because this is meant, points 3 and 4 are meant to explain why it is the child and not the representative who is the right holder. But let's say that it works. I have my doubts, but let's say that this works. Well, it won't work for animals, because they will not grow up to be adults who can then have rights. That is a very big difference. Children will grow up to be adult humans. Animals, of course, will not. And this means that, as far as I can see now, and again, I have not taken part of all the latest writing on this, but this suggests to me that under the will theory, once you bring in the representative, it is the representative who is the right holder, and that is not the result you wanted. You wanted the result that it is the child who is the right holder. But this analysis seems to me, at least, or it does lead to the conclusion that it is the representative. Question is whether there is today some more subtle analysis that I've missed. May well be. I read only a few days ago a paper by Visa Kurki on legal competence, and he discussed disability law, and I'm not familiar with disability law, but he discussed a number of more refined distinctions that could possibly be brought in. But the way I presented it, so this is not super subtle, I have to admit, but the conclusion here is clear. It is what I said in the beginning. That's the way I understand, the way I see things is that the interest theory works in the sense that there are no contradictions or crazy effects. It's simply that you're not saying anything interesting when you speak of rights as of animals as right holders under the interest theory. As far as I can see, you might as well not say anything because you haven't said, there is no content to this. The will theory, on the other hand, I find very interesting. But on this analysis, even if you could make this analysis work for children, which I'm not sure, but let's say you can. Well, you can't make it work for animals, or at least you have to do some creative thinking. And I really haven't done that. I couldn't see. I looked at it, and it seems to me to be a dead end. But perhaps some creative person can get around this. Well, that really is, I'm not quite done, but that is brought out my conclusion. Now I want to say just a few words about, and to me, this is very important. I want to say here at the end that it might sound negative, and some might think that, well, doesn't he care about animals? What kind of person is this? But I believe, as far as I can tell, you might want to show me differently, but as far as I can tell, if we want to protect animals, and I certainly want to protect animals, you can do that whether you think of them as legal right holders or not, because it seems to me that human duties are enough. Claims about animal rights, as I hinted a few minutes ago, may have symbolic value. I don't deny that. And there may be, and symbolic value may be real value. But what I'm saying here that is nothing to do with legal thinking. That's the difference. Finally, I want to just say that I've been going on about conceptual questions, and what is most important, obviously, must be the content and enforcement of animal law and what people actually do. But I do think the reason why I find it worth thinking about conceptual questions in the law is that, at least in principle, some awareness of conceptual questions tends to yield clear thinking, and this in turn it's no guarantee, but it does in principle contribute to both legal correctness, in the sense that you make fewer mistakes and can figure out what the law says correctly, and also to efficiency, in that you don't get sidetracked by pseudo unreal issues, which actually happens sometimes. I've listened to legal colleagues who think they say, oh, analysis, my God, semantics, give me a break. And then in the next minute, they will be making these very crude claims that are simply not based on anything. So first they say you don't need it, and then they bring it in without even realizing it. So I'm suggesting here, finally, before I'll let you go, that conceptual questions are certainly needn't be at the center of anything, but there is some room for thinking about these issues in law and elsewhere. Now, I think I am done. Thank you so much for your attention.